No, you don't have to. You didn't have that water if you'd like.
All right. Good morning. Let the record reflect the state's present, defense counsel's present, and the defendant are all present. And we're ready to continue with the state of Florida versus Wade Wilson, case number 19 CF 568.
Morning, Judge. I think yesterday when we ended, we were discussing the jurors that didn't have a great grasp of English. I did some work last night. I looked at the cases that the state provided, specifically Woodell and DiLorenzo. That appears to be the state of the law at this point. So I'm going to, I haven't presented the court with any testimony or evidence regarding cross-section of the community for Spanish speakers that.
The Durin test, I think is what it's
Correct. But I do want to preserve it for whatever it turns up on appeal. So I would make the motion to include those two Spanish speakers, and I forget their specific numbers or names.
So, and is that then you would request the court to have an interpreter go with them into the jury room for deliberations?
It would probably be necessary, yes.
Okay. All right. So juror, was it 39? Get back to my list.
I thought it was 118.
Mr. Noy.
And
I've got 118 and 201. My office received a message from juror 39 saying she could not return on Thursday.
oh, well, solve that problem.
I don't know if she's one of them.
Yeah, but she isn't one of the two.
She's not one of the two. So I'm just throwing that out there as well.
Yeah.
Did you get the clerk's got something?
So I guess I'm limiting my motion to 118 and 201.
Right. No, I think, yeah, 118, that's right. And 201. Okay. Right. State.
Pause for 118 and 201 based on their limited understanding of the English language.
Well, in my reading of the case law on it now, and correct me if I'm wrong, but I thought juror number 201 had indicated when the state was questioning that he felt like it would be better for somebody else to be sitting as a juror other than him. So I interpret that as him asking to be excused.
In all candor, Judge, I could only understand about one every third word.
Okay.
More than I understood.
Yes. So there's two ways that a juror can not, or potential juror not end up serving in this limited arena or issue. Would be the jurors excused because they are requesting to be excused because they have difficulty with the English language. Also, they can be stricken for cause as a public necessity under the Woodall case. And I think that juror 201 satisfies both of those approaches in terms of him being excused and or stricken for cause. So I will excuse him and strike him for cause as a public necessity under the case law that we previously discussed, but specifically the Woodell case, which is 985 Southern 2nd 524, as well as DiLorenzo and the other citing case law. And then
What you just said applied to 201, correct?
that's a 201.
Right.
And then which was the gentleman. And then 118, just get back to my notes. Juror 118, if the state wanted to address 118.
Yes, Your Honor. I would ask that she be excused also under the public necessity due to her limited understanding of the English language. I think she was very clear that there were some words she wasn't understanding. She was missing part of what you had said in your preliminary instructions, as well as some of the questions I asked her. It seemed clear to me in the way she was responding to my question that she did not fully understand. And I believe she would be someone who was.
Okay. All right. So as it relates to juror 118, I believe also in the questioning, she said something to the effect of probably, yeah, that she had difficulty or understanding what was being said and that she would have difficulty listening to the evidence and understanding it. So again, under both of those prongs, or not prongs, but vehicles, I guess, for not serving on the jury, whether it be an excusal because of her difficulty and not being able to comprehend things and follow along, as well as the public necessity for cause under the Woodall case as well, then she'll be excused and or stricken for cause as well.
As long as, just as long as the objections noted on both of them.
The objections are noted.
Reserved. Thank you.
You're welcome. All right. Anything else?
Because of juror 39 calling and saying they couldn't make it Thursday, or is support there?
No, I think at this point, we'll see what happens Thursday. My office just indicated she needed to talk to the jury clerks. She did call.
Instructed her that she was ordered to return on Thursday and that she should be here 9 o'clock.
Okay, good. So we can talk to her Thursday.
She
then.
did cite something about made an appointment, something to that effect. And then she had trouble finding parking and just a bunch of different reasons.
I understand. So I just wanted to put that on the record that was the communication that I had received. All right. So we'll still expect hopefully to see her Thursday morning at 9 o'clock, but anything else? All right. So we have 60.
Line them up right now.
Great. And then have you got preliminary instructions? Great.
Judge, I believe they're before you.
They are. Thank you. All right. Has defense had a chance to look at the new and improved preliminary instructions?
We should have only been
In the last one you read.
I think you just corrected some.
Line out.
Yeah,
right.
that's correct, isn't that? Mr. Gardner, it's just corrections of the minor things we did yesterday.
Correct.
Okay.
The one line on page 8 that
Yes, that looks like it's correct. And just make sure. And I think that the alleged date of the offense is corresponding with the way it's written in the indictment as well. That's what I was saying. So it's not confusing the jury in terms of a date. But okay. All right then. All right then. Are we ready once they're lined up to bring everybody in? Okay. Defense is ready.
As soon as we spin around.
What's that?
As soon as we spin around.
Go ahead.
Sir, I'll switch here.
A question?
Yes.
If we get our jury selected by Thursday evening.
Okay.
Are you going to want us to start testimony and openings Friday? Or come back Monday? Our first.
My original plan was to come back Monday,
Okay.
but if you all say
No.
you're ready and we can get a day out of the way, I will not. I mean,
I just think it makes more sense to come back Monday. If we, not that we have to accommodate Mr. Holloway and I, but we're sole practitioners.
Yeah.
Trying to keep our ship afloat.
I understand.
Okay. Thank you.
I
We could do either one. Would be our first.
let's kind of see. My plan is still to start Monday. I mean, if we, perhaps, I'm not encouraging anybody to slow down in order to avail themselves of a Friday to take care of other things. But if we can, if we're in a position where both parties are like we're ready, then I don't have a problem starting Friday. But like I said, and what I told the jurors is we wouldn't start until Monday. If we start next Monday, you think we would be on schedule? Okay.
Good.
Shocked.
Mhm.
Finds painful and uncomfortable if it's also on the Belmont. And he was asking subject to some other restraint, form of restraint can go without shock.
Well, I think that was, yeah, they did that so that he wouldn't have to be in type of handcuffs or shackles or anything like that. I don't know of any other one.
Issue, but he cares about the appearance of the shackles.
Well, the security belt is something that's not seen by the jurors or anything. It's under his clothes. So, yeah, but you still can't see that. Yeah, I can hear it, but when you hit it, but I can't see it.
So, it's right there.
A hernia, it upsets my hernia. It hurts.
Uh,
It hurts my hernia.
okay. Well,
I have a hernia belt on also with this belt on top. It's extremely uncomfortable.
okay. Well, I mean, I'll let you all discuss the other option, which again, you have to probably have some type of other restraints to be visible to the jury.
No,
What's that?
it was my understanding you wore no.
I told them they could put the belt on as opposed to having the visible restraints.
So if they and he work out a different solution,
They'll bring it to me and I'll listen to it. I'm not sure if they can adjust the two belts so that they're not causing any discomfort or what have you, but I imagine that could be done. I know he was in the security belt yesterday, and there was no complaint, so I'm not sure what's different today.
just it's gotten worse. I mean, yesterday you kind of sucked it up and dealt with it. So today he was trying to see if we could do something different.
Well, like I said, I don't think there was nothing brought to the court's attention yesterday.
There was
Okay. All right.
was
Okay.
just saying that today's a little
Okay.
more uncomfortable, painful.
Well, what do you want me to do, Mr. Hollander?
I just want to know that if we can come up with some other resolution that the court is willing to listen to it.
Always willing to listen to other resolutions, but right now I don't have anything. I don't know of anything else. You haven't suggested anything else.
So I need to talk to the bailiff.
Okay.
Thank you.
So I don't know if it can be adjusted differently than it is right now. Okay. Can it be? Was it adjusted differently yesterday than it is today? Okay. Was it different? I mean, Mr. Hollander, is it in a different position today than it was yesterday?
That I don't know.
Okay.
Specific. On the next break, I'll talk to my client, talk to bailiffs, and see the alternatives. I'm not sure he's not as worried about the appearance of the shackles at this point. I mean, it's kind of obvious it's in custody.
Well, this appears to be the least visible, the least impressionable upon the jury. It provides security for the court as well as for Mr. Wilson as well. It's there to protect everybody involved. So unless you have something specific, I'll wait for you to bring that up. But there's nothing specific that I can tell you're requesting me to do right now. So I'll wait until you bring something specific.
Thank
All
you.
right. All right. You all can be seated. We're standing for you.
Your panel, Your Honor.
All right. Thank you. Please be seated. All right. All right. Good morning, ladies and gentlemen. Welcome to the Felony Division of Circuit Court. You've all been called for jury service in the case of the state of Florida versus Wade Wilson, case number 19 CF 568. I'm Judge Nick Thompson, and I'll preside over this case. Is the state ready for trial? All right. Is the defense ready for trial? Now, we know that you all have been waiting for a while this morning, and I want to thank you for your patience. We've done everything possible to reach this point quickly. Let me ask all the jurors, did the jury clerk swear in all of you as a panel? Okay, is there anybody who believes they were not sworn in? Please raise your hand. All right, seeing no hands, we're ready to proceed. Before we go any further, I want to introduce some of the courtroom personnel assisting me during this trial. As a judge, my job is to maintain order in deciding on how to apply the rules of law to the trial. It is my job to remain neutral on the issues of the case. I will explain the rules to you, and explain the rules we use that you will use. I'm sorry, as jurors. The deputy clerk is seated at my right, and the clerk assists with the mechanics of the trial, swears in witnesses, keeps minutes, and handles the exhibits, and helps with other miscellaneous duties. The court reporter is seated directly below the bench. The court reporter's responsibility is to take down everything that everyone is saying in the courtroom accurately. To help with that, please don't speak simultaneously and say everything clearly so the court reporter can hear your response. The court reporter cannot transcribe when you nod your head or shake your head. So please try and answer any questions posed to you with a verbal response. Assistant State Attorneys Andreas Gardner and Sarah Miller represent the state of Florida. Mr. Kevin Shirley and Mr. Lee Hollander represent Mr. Wilson. Do you know me, the deputy clerk, the court reporter, the attorneys, or the defendant? By a show of hands. Some hands back here. All right. What is your juror? Oh, okay. Let me start with the second row. In the second row, no one in the first row, right? Okay. Second row, what is your juror number? Okay. Okay. And then no one on the second row on this side. Oh, first row. I'm sorry. Wait 1 second. Let me say juror number 313. We'll come back to you. I just want to get the numbers of people raising their hands. And that's in the third row. Yes, sir. What did you say? 380. Okay, I see. And then anybody in the fourth row? No. Fifth row in the back. What is your juror number? Okay, very good. All right, we'll come back to you all.
Gentlemen on the aisle here.
In the back, that was.
Okay.
Yep. All right. All right, to have a fair and lawful trial, there are rules that all jurors must follow. A basic rule is that jurors must decide the case only on the evidence presented in the courtroom. You must not communicate with anyone, including friends and family, about this case, the people and places involved, or your jury service. You must not disclose your thoughts about this case or ask for advice on how to decide the case. Do not send or accept any messages to or from anyone about this case or your jury service. This rule means you must not use electronic devices or cell phones to communicate about this case, including tweeting, texting, blogging, emailing, posting information on a website or chat room, or any other means. In addition, your cell phone or electronic device must be turned completely off while you're in the courtroom. This rule applies in the courthouse, at home, or anywhere else. You must not do any research or look up words, names, maps, or anything else that may have anything to do with this case. This includes reading newspapers, watching television, or using a computer, a cell phone, the internet, any electronic device, or any other means to get information related to this case or the people and places involved. We all depend on you to follow these rules, so there will be a fair and lawful resolution to this case. Unlike questions that you may be allowed to ask in court, which will be answered in court in the presence of the judge and the parties, if you investigate, research, or make inquiries outside the courtroom, the trial judge has no way to assure they are proper and relevant to the case. The parties likewise have no opportunity to dispute the accuracy of what you find or provide rebuttal evidence. That is contrary to our judicial system, which assures every party the right to ask questions about and rebut the evidence being considered against it and to present an argument concerning that evidence. Any juror who violates these restrictions jeopardizes the fairness of these proceedings and could cause a mistrial that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions, such as serving time in jail, paying a fine, or both. If you become aware of any violation of these instructions or any other instruction I give in this case, you must tell me by giving a note to the bailiff. You have been selected and sworn in as prospective jurors for the case of the state of Florida versus Wade Wilson. This is a criminal case. The state's charging document, called an indictment, is not evidence and is not to be considered by you as any proof of guilt. The indictment reads as follows. In the Circuit Court for the 20th Judicial Circuit of the State of Florida, Lee County, in the year of our Lord 2019, case number 19 CF 000568, State of Florida versus Wade S. Wilson. Indictment 4, Count 1, first-degree murder. Count 2, grand theft motor vehicle. Count 3, battery. Count 4, first-degree murder. Count 5, burglary of a dwelling. Count 6, first-degree petty theft. Count 1, first-degree murder alleges that on or about October 7th, 2019, in Lee County, Florida, did unlawfully, from a premeditated design to effect the death of a human being, kill and murder Christine Melton, a human being, by compressing her neck or strangling her, contrary to Florida statutes 782.04, subsection 1. Count 2, grand theft of motor vehicle, alleges that on or about October 7, 2019, in Lee County, Florida, did knowingly attain or use or endeavor to obtain or use a motor vehicle, the property of another, to wit, Christine Melton, as owner or custodian thereof, with the intent to temporarily or permanently deprive the owner or custodian of a right to the motor vehicle or benefit therefrom, or to appropriate the motor vehicle to the defendant's own use or to the use of any person not entitled thereto, contrary to Florida Statute 812.014. Count 3, battery. On or about alleges that on or about October 7th, 2019, in Lee County, Florida, did unlawfully commit a battery upon Melissa Montanez by actually and intentionally touching or striking said person against said person's will, or by intentionally causing bodily harm to said person, contrary to Florida Statute 784.03. Count 4, first-degree murder, alleges that on or about October 7th, 2019, in Lee County, Florida, did unlawfully, from a premeditated design to effect the death of a human being, kill and murder Diane Ruiz, a human being, by compressing her neck or strangling her and/or inflicting blunt traumatic injuries, contrary to Florida Statute 782.04, subsection 1. Count 5, burglary of a dwelling, alleges that on or about October 7, 2019, in Lee County, Florida, did unlawfully enter or remain in a certain structure, to wit, a dwelling, in the county and state aforesaid, the property of Kent Amlin or Fanny Amlin as owner or custodian thereof, with the intent to commit an offense therein, to wit, theft, contrary to Florida Statutes 810.02. Count 4, first-degree petty theft, alleges that on or about October 7th, 2019, in Lee County, Florida, did knowingly obtain or use or endeavor to obtain or use or to appropriate to his own use or to the use of any person not entitled thereto the property of Kent Amlin or Fanny Amlin, valued at $100 or more, with the intent to temporarily or permanently deprive the owner or custodian of a right to the property or benefit therefrom, or to appropriate the property to the defendant's own use or to the use of any person not entitled thereto, contrary to Florida Statutes 812.014. Now, the definition of first-degree murder and the other charges will be explained to you later. It is the judge's responsibility to explain the law to you. It is your responsibility to determine if the state proved its accusations beyond a reasonable doubt against Wade Wilson in accordance with the law I provide to you. Thus, the province of the jury and the court are well defined and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. The first part of every jury trial is the voir dire examination or jury selection. The purpose of jury selection is for the parties to determine if your verdict in this case would be influenced by any experience you may have had, any opinions you now hold, or any special training or knowledge you may possess. Please understand that the questions that will be asked aren't intended to pry into your personal affairs or embarrass you. As we go through this process, if you feel more comfortable giving those answers privately, we can accommodate that by letting you come up to the bench to explain further for the parties and me. After the jury is selected, the parties will have an opportunity, if they wish, to make an opening statement. The opening statement lets the parties tell you what evidence they believe will be presented during the trial. What the parties say is not evidence, and you should not consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the parties. The documents and other exhibits also may be produced as evidence. After the evidence has been presented, the parties will have the opportunity to make their closing arguments. Following the closing arguments by the parties, the court will conclude with the final instructions. After giving the final instructions, you will retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all the evidence, the argument of the lawyers, and the instructions on the law by the judge. Until that time, you should not discuss the case even among yourselves. Your verdict must be based solely on the evidence or lack of evidence and the law. This is a capital case concerning 2 counts of first-degree murder. The state has served notice that it is seeking the death penalty against Wade Wilson regarding the deaths of Christine Melton and Diane Ruiz. Capital cases are tried in 2 parts. The first part, or the guilt phase, is conducted as I have just described. If the guilt phase results in a finding of guilt for first-degree murder, the court must conduct a penalty phase hearing. Please remember that the defendant is presumed innocent, so the fact that I'm discussing potential penalties should not change that presumption. Because this is a capital case, we need a panel of 16 jurors who can serve for 2 to 3 weeks. Most criminal trials in this circuit are over in just a few days, some are not. This one may take 2 to 3 weeks. We recognize that serving on a jury for 2 to 3 weeks can present a hardship for some of you. I will allow you to tell me if things in your life could keep you from serving as a juror in this case. We may be able to work around some of these hardships, but please understand that your definition of hardship may not meet the legal definition, and I must follow what the law says. We will try to accommodate your concerns as best we can. However, you may still be asked to serve even if it may be inconvenient. Some examples of hardship might include scheduled surgery, serious illness, a medical or mental condition that would make it challenging to serve, or a significant financial problem. Significant hardships would cause you to go into serious debt, make it impossible for you to pay your bills, or result in you being evicted. To consider these potential hardships, we will have to ask you some questions and make decisions on a case-by-case basis. To give you an idea about the anticipated schedule, we expect to spend this week selecting a jury, though you will likely not be required to be here more than 2 days during that process. If we complete the jury selection process as expected, we will start the guilt phase on Monday of next week. We expect the guilt phase will take 3 to 4 days. As I stated, if the defendant is found guilty of first-degree murder of Christine Melton and/or Diane Ruiz, we anticipate that 2 to 3 days will be needed to complete the penalty phase. There will likely be a short break between the two phases where your presence in court will not be necessary. This discussion of a possible penalty phase should not cause you to believe that the court believes you will return a guilty verdict. We are discussing this only because it is one possible outcome that could influence the time required to complete this case. If the defendant is found guilty of a crime other than first-degree murder or not guilty, you will have completed your jury service, and a penalty phase hearing will not be necessary. I want to explain how a penalty phase would be conducted if Wade Wilson is found guilty of first-degree murder of Christine Melton and/or Diana Ruiz. At the beginning of the penalty phase, the parties would have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the penalty phase of this trial. What the lawyers say during opening statements is not evidence, and you are not to consider it as such. After the attorneys have had the opportunity to present their opening statements, the state and the defendant may present evidence relative to the nature of the crime and the defendant's character, background, or life. You are instructed that this evidence, along with the evidence that you heard during the guilt phase of this trial, is presented in order for you to determine as you will be instructed. 1, whether each aggravating factor is proven beyond a reasonable doubt, and 2, whether the defendant should be sentenced to life imprisonment or death. At the conclusion of the evidence and after argument of counsel, you will be instructed on the law that will guide your deliberations. An aggravating factor is a standard to guide the jury in making the choice between a verdict of life imprisonment or death. It is a statutorily enumerated circumstance that increases the gravity of a crime or the harm to a victim. You must unanimously agree that each aggravating factor was proven beyond a reasonable doubt before it may be considered by you in arriving at your final verdict. In order to consider the death penalty as a possible penalty, you must unanimously determine that at least one aggravating factor has been proven beyond a reasonable doubt. The state has the burden to prove each aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return an aggravating factor if you have an abiding conviction that it exists. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proved beyond a reasonable doubt, and you must not consider it in providing your verdict on the appropriate sentence to the court. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, conflicts in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find that the aggravating factor does exist. If you find that at least one aggravating factor has been proven beyond a reasonable doubt, you will then be asked to make a recommendation as to whether the defendant shall be sentenced to life imprisonment or to death. Your recommendation must be based on a weighing of all of the following. 1, whether the aggravating factors that you unanimously find beyond a reasonable doubt are sufficient to impose a sentence of death. 2, whether the aggravating factors that you unanimously find beyond a reasonable doubt outweigh the mitigating circumstances you find to exist. 3, based on these two considerations, whether the defendant should be sentenced to life imprisonment or to death. If at least 8 jurors determine that the defendant should be sentenced to death, the jury's recommendation to the court must be a sentence of death. If fewer than 8 jurors determine that the defendant should be sentenced to death, the jury's recommendation to the court must be a sentence of life imprisonment. Unlike aggravating factors, you do not need to unanimously agree that a mitigating circumstance has been established. Rather, when a mitigating circumstance has been established, it is an individual judgment by each juror. A mitigating circumstance is not limited to the facts surrounding the crime. It can be anything which might indicate that the death penalty is not appropriate for the defendant. In other words, a mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that reasonably may indicate that the death penalty is not an appropriate sentence in this case. A mitigating circumstance need not be proven beyond a reasonable doubt by the defendant. A mitigating circumstance need only be proven by the greater weight of the evidence, which means evidence that, more likely than not, tends to prove the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you may consider it established and give that evidence such weight as you determine it should receive in reaching your conclusion as to the sentence to be imposed. Regardless of the results of each juror's individual weighing process, even if you find that the sufficient aggravating factors outweigh the mitigators, the law neither compels you nor requires you to determine that the defendant should be sentenced to death. I remind you that this discussion of a possible penalty phase should not cause you to believe that the court believes you'll return a guilty verdict. We are discussing this only because it is one possible outcome that could influence the time required to complete this case. We will begin this process in just a few minutes by breaking you into smaller groups to be brought to the courtroom and asked about the following: potential hardships you may have, your knowledge regarding this case, including exposure to pretrial publicity, and your views on capital punishment. To aid in our inquiry regarding your knowledge related to this case, the court and the parties have agreed to advise you that the defendant in this case is Wade Wilson. He is charged with first-degree murder of Christine Melton on or about October 7, 2019, and first-degree murder Diane Ruiz in the city of Cape Coral, Florida. Please answer the voir dire questions honestly and candidly if selected as a juror. Listen with an open mind to the testimony, follow the law, and render a true and just verdict based on the facts you find in light of the laws I'll give you. During this process, the parties will be questioning you. We only ask your answers to be honest. There are no wrong answers. The integrity of the jury system rests entirely on the honesty of the jurors. Each of the parties will have specific questions they will ask you. Some of these questions will be asked of you individually, and others will be asked of you in a group setting. Following the parties' questions, I will then meet with the parties to determine who will become the jurors to try this case. The object of voir dire is to obtain a jury that will impartially try the issues of this case on the evidence presented in this courtroom without being influenced by any other factors. Some questions related to your views on capital punishment you may be asked are: 1, whether you have any moral, religious, or personal feelings sitting in judgment of a defendant's conduct in this case. 2, whether you have strong feelings about the death penalty. 3, whether you are in favor of the death penalty. 4, whether or not you agree with the premise that a sentence of death is not appropriate for all first-degree murder cases. 5, whether you would agree to weigh the aggravating factors and mitigating circumstances with an open mind and determine whether death or life imprisonment would be an appropriate sentence. 6, whether you are unalterably opposed to the death penalty such that you would not consider it as a penalty under any circumstances. 7, whether your opinion concerning the death penalty would substantially impair your ability to follow the court's instructions. Many people have strong feelings about the death penalty, both for and against it. That you may have such feelings does not disqualify you from serving as a juror, as long as you can put those feelings aside and apply the law as I instruct you. In other words, you must be willing to be bound by your oath as a juror to obey the laws of the state in delivering your verdict. So with that, just a couple of things for everybody before we break up in groups. Obviously, you can see some cameras in the courtroom. There is media attention on this case. They will not be broadcasting your identities or your faces during the trial. But because there's media attention, I want to reemphasize, do not look up anything. Do not go on the internet or look up anything regarding this case or anything about it. Like I said before, do not discuss this case with anyone, even among yourselves at this point. And the other thing is you may run into the parties at different times during recesses or what have you. They're all instructed not to communicate with any potential jurors or jurors. So if you ordinarily would say good afternoon or good morning and they avoid you and they don't say anything back, they're not being rude. They're just following the court's orders. All right. Now, with that, we're going to, I'm going to call out a list of juror numbers. So make sure, does everybody have their juror number in front of you? Know what your juror number is. And I'm going to call them out. And then we're going, if your name is not called, then you're going to be escorted to another courtroom. I'm sorry, no, if your name is not called, we're going to have you'll be released this morning and then come back 2 o'clock, 1 o'clock, 1:30? I think 1:30, which should give us enough time. So if I do not call your number out, you're going to be excused. You have to come back at 1:30. If I do call your number, stay here, and then I'll give you some more instructions. So everybody understand? Everybody got their number? You have your number? Hold on 1 second. They're gonna tell you, the bailiffs will tell you where to come back. So we'll make sure the bailiffs have you fully instructed on where to meet and all that as we proceed. What? Yeah, I think that's probably better. All right. So I'll call out these numbers. Juror, let's see, 218 114 313 234 78 101 201 41 346 77 2 60 79 361 228 356 251 229 210 160 380 56 75 73 283 103 196 264 305 299. All right. So if I did not call your number, you will come back. The bailiffs will tell you where to go, correct? You have the place for them. Come back at 1:30. And with that, the people I did not call are excused to go with the bailiff. So I don't know if it can be adjusted differently than it is right now. Okay, can it be, was it adjusted differently yesterday than it is today? Okay, was it I mean, Mr. Hollander, is it in a different position today than it was yesterday?
That I don't know.
Okay,
On the next break, I'll talk to my client, talk to Bales, and see his alternatives. I'm not sure he's not as worried about the appearance of the shackles at this point. I mean, it's kind of obvious he's in custody.
well, this appears to be the, least visible, the least impressionable upon the jury. It provides security for the court as well as for Mr. Wilson as well. It's there to, protect everybody involved. So unless you have something specific, I'll wait for you to bring that up. But there's nothing specific that I can tell you're requesting me to do right now. So I'll wait until you bring something specific.
Okay,
All right. All right, so those who are remaining, the bailiffs will escort you to the other courtroom, and then we'll call you in as we need. Okay? All right, let the record reflect that all the jury panel members have exited the courtroom. All right. And Mr. Hollander, I know you raised an issue about juror 380
Yes, sir.
and his employment. And I'm not sure, is there a statutory exemption for them? Is that why?
I don't know for that specific.
Okay, I didn't know if that's why you're raising it right now. Okay.
No.
Okay. Well, and there's some statutory exemptions in the statute. I wasn't sure if that was one of them, but otherwise, like I said, we'll just go through the process and we can ask them about it. Okay, and we can find out before then. All right, then. Are any objections to the instructions as read?
No, Judge.
All right. Can we call in then the next, or I guess the first potential juror, which is going to be 218? All right. Let's go. The defense is ready?
Yes, sir.
Okay.
A lot of media last night and this morning. Sure.
Sit in the chair right there behind the microphone, right behind the microphone. Thank you. Good morning. Are you juror 218?
Yes, sir.
All right, I'll let the state begin their question.
Good morning.
Morning.
You have the advantage of being the first one this morning. I don't know if advantage is the right word, but my name is Sarah Miller, and this is Andreas Gardner, and we represent the state of Florida. We just have a few questions we want to ask you. The judge spent a lot of time explaining the process, and throughout the trial, he'll continue to explain the process. It's obviously a new process for most people, not something that they've experienced or done before. First of all, have you heard anything about the case on the news or through social media prior to coming here today?
Yes.
And how did you hear about the case?
I've been following the case for a while,
And what is it that you know or that you've heard about the case?
but murder in two young ladies in the Cape Coral.
All right. Now, obviously, what comes out on the news could or could not be true. Would you agree that what's on the news is not always accurate?
Sometimes.
Now, the way in trial that it works is that it's our burden. The state has to present the evidence. We have to prove the charges. And the only evidence that jurors can consider is the evidence that comes out in this courtroom. Would you be able to disregard anything you may have heard or seen about this case and decide this case solely on the evidence from this courtroom?
Yes.
Okay. And you're hesitant. Do you feel like you have your mind made up, or do you think you actually could listen to the evidence?
Well, as the judge says, we're not supposed to research and stuff, but I already did that.
So you've already researched. Would your research get in the way of your ability to be fair and impartial in this case, or could you set that research aside?
Not sure.
Okay.
I didn't hear your answer. I'm sorry.
Not sure.
All right. Do you think that research has somewhat influenced your opinion already on this case?
Some of it, yes.
I have no further questions. Thank you.
All right. Okay. All right then, ma'am. Your jury service is complete for the year, and you are released. And the bailiff will escort you out.
Thank you.
Thank you. I didn't know if somebody's talking to the prospective jurors out there. Are you sure? Okay. Okay. All right then. Just for the record, it was caused by the state and no objection from the defense.
Right.
Okay. All right then. Juror 218 stricken for cause. Are we ready to bring in juror 114?
Juror entry.
All right, sir, just take a seat behind the microphone. And are you right behind the microphone? Not that one, right there. Sorry. That second seat in.
Second seat. Okay.
There you go. You can be seated. Are you juror 114?
Yes, I am.
All right, I'll let the state begin their question.
Good morning.
Good morning.
How are you today?
Fine, ma'am.
I'm Sarah Miller. This is Andreas Gardner, and we're here on behalf of the state. This is a relatively short part of the trial where we are just asking background questions to see if people are qualified to sit on this case. And the judge spent a lot of time giving you information about this trial and how it works. So I'm not going to take a lot of time going through that because he'll go through that as we go along. As far as pretrial publicity, have you seen or heard anything on the news about this case prior to coming in today?
No.
As far as hardship goes, over the next 3 weeks, do you have any surgeries or financial hardship or anything we need to know about as to why you would not be able to serve?
No.
All right, moving on to the little bit tougher question. As the judge said, the state has decided to seek the death penalty in this case. And that's not a common occurrence, but in this case we have. And because of that, the jurors actually will get to make a recommendation as to the sentence. Typically in a trial, once the jury has decided guilty or not guilty, it's up to the judge to decide the outcome if they're convicted. But in this case, after the guilt phase, if the jury has unanimously agreed that the state has proven one count of premeditated murder beyond a reasonable doubt, then the jurors come back for the penalty phase. And during that penalty phase, you'll hear aggravating factors that the state will present. And those aggravating factors are very clearly laid out in the statute of what we have to show. And then the jurors have to find at least one of those aggravating factors was proven beyond a reasonable doubt. The defense can present mitigating circumstances. And after you hear all that, it will be your decision as to whether to recommend either death or life. And life means life. There's no parole, or the death penalty. Now, do you have any religious beliefs or moral opposition or just any feelings from maybe your life that would make you opposed to the death penalty? So just to dig a little further, a little deeper, a lot of people, when it comes to the death penalty, have strong opinions. They have strong feelings, and some people just feel sort of neutral. So you have the one end of the spectrum where jurors or people may say, listen, I think if you take a life, you deserve to have your life taken, no matter what. Life equals life. Then you have people on the other side that say they don't agree with the death penalty for whatever reason. They think it's barbaric or inhumane, and that no matter the circumstances, no matter who's killed, no matter the facts, no one should ever get the death penalty. And then there's people that fall more in the middle, that say they would listen to it on a case-by-case basis. Some cases are deserving of death, some cases are not. Where would you say on that spectrum that you fall?
In the middle.
Okay. Now, again, it will be up to you to decide what weight to give certain factors. Do you believe that after hearing the factors and hearing the evidence, that if you believe the circumstances warrant it, that you could recommend a sentence of death?
I understand the full gravity.
Sure.
No one looks forward to being placed in this position. But if I'm focused on just the legal definitions and legal requirement and weighing evidence beyond personal feelings, I think I can do it.
Okay. And then the same question is, if you hear all the evidence and you believe doesn't warrant the death penalty, would you be comfortable recommending a life sentence?
Yes.
And obviously we recognize this is a huge responsibility, that it's a big ask to ask someone to make that type of decision. But based on just the serious responsibility in your own.
You understand that in the state of Florida, if somebody likes that, what they get, there's no parole anymore. So if you go into prison, you never come out again. Do you understand that?
Now I do.
Okay. So that's one of the two options that you would have if you're selected as a juror. And if the state of Florida proves either one of the homicides beyond every reasonable doubt, then you would have either life in prison for the rest of the inmate's life or the death penalty as one of the two sanctions. You understand that?
Yes.
Okay. Real quick, the judge threw a lot of concepts and law at you when you were all sitting out there as a panel. Let me go over this real quick. The state has the burden of proving aggravating factors. Now, the judge used the term enumerated. Basically, in this case, what that means is there's just a finite number of enumerating factors that you can consider. You can't consider any emotional or anything like that. The judge would tell you which ones you're allowed to consider. Do you understand? In the state of Florida, needs to convince you that they have proven the aggravating factor or factors beyond every reasonable doubt. It's the same burden of proof that you would consider as to whether or not he had committed either one of the homicides. Same burden of proof. Do you understand? Okay. You have to say yes or no.
Yes.
Thank you. Now, not only do they have to convince you, but they have to convince all 12 jurors that they have proven it beyond every reasonable doubt before you can even go on to the next step. Do you understand that?
Okay.
All right.
Yes.
So let's say the state has proven at least one aggravating factor beyond every reasonable doubt. Then you go to the next step. Well, the next step is for you to consider mitigating circumstances. The reason they're not called mitigating factors is because mitigating circumstances only need to be proven by a greater weight of the evidence, a little more than not. You understand?
Okay.
You know,
Yes.
in your own mind, whether that's a 51% or a 52% or whatever, but it's a little more than not. Okay?
Okay.
Now, important thing to remember is there's a presumption of innocence that just because he's found guilty of one of the two homicides doesn't mean that presumption just fades away. There's still a presumption of innocence with regard to Mr. Wilson, which doesn't require him to show any mitigating circumstances. He doesn't have to testify. We don't have to put on any witnesses. Do you understand that?
Yes,
Okay. And among the mitigating circumstances, do you think it's possible that you could consider mental health mitigation?
yes, I could.
Okay. Now, then you go through another weighing process, but it's a little bit different. Each individual juror determines whether or not there are mitigating circumstances and whether or not they've been proven. And then you decide individually whether or not the mitigators outweigh the aggravators or the aggravators outweigh the mitigators. Okay. And it's not just a sheer number like 4 aggravating factors versus 7 mitigating factors. Each one of those factors and circumstances, each one of those factors and circumstances have to be weighed against each other for you to make a determination as to whether or not either has outweighed the other. But if you make the decision that the aggravating fact, oh, well, let me back up a second. If you decide the mitigating circumstances outweigh the aggravating factors, then you're done, and the recommendation is life.
Okay.
But if you determine that the aggravating factors outweigh the mitigating circumstances, then you go on to the final step. In the final step, you mentioned something about following the law and going beyond personal feelings. Well, the last step, as the judge has already told you, that there is nothing in the law that compels you to return a recommendation of death. So even if the aggravators outweigh the mitigators, if there's something in the back of your own mind, some question in the back of your own mind that says, not this case, I can't recommend death on this case, then you have the right, the duty to come back with a recommendation of life. Do you understand?
Yes, sir.
Okay. And it takes a recommendation of 8 people to vote for death in order for it to go to the court as a recommendation of death by the panel as a whole. You understand?
Yes, sir.
Okay. And if you're one of those people, when it gets near the end, that says, I don't think death is appropriate, are you willing to stick by your guns and look the other jurors in the face and say, I'm sorry, you have your opinion and I have mine?
Yes, I am.
All right. I have no further questions. Thank you, sir.
All right.
Okay.
All right, sir. We're going to have you come back on Thursday morning at 9 a.m. The bailiffs will tell you where to go. It'll be the jury waiting room again on the 2nd floor to start with. Just come be there by 9 a.m. Please remember my earlier instructions. Don't look up anything about the case. Don't do any research. Don't watch local news media. And don't discuss anything about this case with anyone, okay?
Yes, sir.
All right. We'll see you Thursday morning at 9 a.m. Yes. Yes.
Just got more straight. The other court, no, they're holding. Okay, this
Dolphin approach.
approach.